Okay, hello everyone. Thank you very much for joining us today. My name is Sydney Cherubin. I'm the Director of Legal Services at the Brooklyn Bar Association Volunteer Lawyers Project. The mission of the VLP is to ensure that the legal system is accessible to those because of a special need or overwhelming burdens of poverty would not otherwise have their rights protected or their voices heard. For the last 30 years, the VLP has harnessed the powerful pro bono commitment of the private bar to provide critical legal services, civil legal services, and equal justice to thousands of Brooklyn residents. As an essential legal lifeline, the VLP remains uniquely responsive to the evolving legal needs of Brooklyn's overlooked and underserved communities. The VLP's primary referral areas are family law, elder law, and consumer law, including Chapter 7 bankruptcies, CLARO, which is our civil legal advice and resource office for people being sued in consumer credit matters, and the foreclosure intervention program. In addition to serving those in need through direct representation, the VLP has established several innovative education and outreach programs for seniors and self-represented litigants. The VLP is very excited to be partnering with the Brooklyn Bar Association's Trust and Estates and Surrogates Court Committees to provide much needed services to families who have been affected as a result of COVID-19 through the VLP probate initiative. As a result of the state's significant death toll due to the coronavirus pandemic, we have already begun seeing a surge in coronavirus-related estate cases. And so we're happy to be presenting today and hoping to meet those needs when people start to reach out. Volunteer attorneys will be providing pro bono legal assistance to qualifying individuals and families in completing applications for voluntary administration for estates of $50,000 or less and SCPA 1310 affidavits regarding payment of certain debts without administration. And so I'm happy to be on the panel with Daniel Antonelli, Carrie, I almost said Carrie Washington, Carrie Archer, and Walker, and Lisa Mathis. They're experienced and have been doing this work for quite some time, and we'll be sharing a lot of great information with you. So I think at this point, I'm going to turn it over to Danny, and I'll be back a little bit later to talk about the VLP's intake process and how people can get access to death certificates. So Danny, I'm going to turn it over to you.
Thanks, Sydney. So just a couple of housekeeping items. I've mentioned this before we got started, but your course materials have been updated just slightly. A few more materials have been added, some slight changes, nothing critical. It is available right now. If you go over to the chat section, if you don't know how to get there, just go down to the bottom of your screen, click on chat, and then a window should open up, and there's a link there to all of the updated materials. Again, it's not critical for the presentation. It'll just maybe help you follow along. If you can't locate it, we will definitely get it to you after the program. And also, we provided the individual materials. Most of them, or a lot of them, as Word templates, so they'll be easier for you to use. So the vision for this project is that we are trying to help those New Yorkers who have been hit hardest by the COVID crisis, namely those with limited financial means, who have lost a loved one, and where that loved one has left a small estate. With a significant estate, it's pretty easy to get an attorney to represent you. When you have a small estate, it's often more difficult. And even if you can find somebody to represent you, the attorney fees tend to eat away at maybe a $10,000, $20,000, $30,000 estate. So our goal is to provide some relief to these New Yorkers. And we thank everybody for being here. We've got a great crowd of about 40, and we hope everybody is able to take a case and we're able to help a lot of people. So the next thing we're going to cover is the intake process that the VLP is going to do. So so the VLP is sourcing clients for us. So as potential pro bono clients come in, they're going to contact the VLP, and we want to give you a little bit of an idea about what the VLP is going to be doing and how they're going to make the referral. So back to Sydney.
Okay. So we have already started getting calls regarding this issue, and we have a couple of people already on our wait list. So what we've been doing at the VLP is we've been conducting a preliminary intake with them. We're making sure they meet our eligibility requirements. Once we determine that they have met our eligibility requirements, we are then completing an intake with them and getting information, basic information about their case. And then we're encouraging them, if possible, to gather as much documentation as possible. Death benefit or death certificates, if they have it, if they have funeral bills, that they have receipts for, anything that might be helpful to you as a volunteer who's going to be helping the client. We're going to try to gather that in advance. And so I will preface it with, we'll make best efforts to do that, but sometimes you may need to follow up with the client once the client is assigned to you. And once we've completed the intake and there is a wait list, we will then reach out to the attendees to let them know that we have a case available that's ready for assignment. And with that case, you will get an email, or probably not a printout, but an email with this information that you see on your screen here. It'll capture this information. I think there's a second page to that intake checklist.
So it actually just goes to the instructions.
That's for you guys. But we will send the relevant information that we've gathered from the client over to the attorney once they accept the case. In addition to this document, you will also receive our legal retainer and a statement of client rights, which you will go over with the client and fill out. I want you to know that everyone participating through this program and working through the VLP will be covered by the VLP's malpractice insurance. So you are covered as a VLP volunteer through our malpractice. We don't want to have to use it. So, but we have wonderful mentors here on the panel who are here to answer questions and review anything before they are submitted. So that's how the intake process will work. We started advertising about the program. We have a few people who have expressed an interest. So as soon as the CLE is over, you're able to reach out to us directly, or we will be sending out an email to let you know that we have these cases available and that they're ready for assignment.
Right. So Sydney, this is Pam Walker. I just want to add a couple of things to this. So this VLP intake checklist was, Sydney is putting this into his database. So when a potential client calls in, this information is cleared through his staff. And then this form will be generated for the attorney who takes over the matter. So you will have this information before you even meet the client. You will know, information about the client, whether they have assets over $50,000 or under. Of course, we're only doing $50,000 or less. Whether they have real property. A caveat: I spoke to a client yesterday. If they have a Mitchell-Lama apartment, it may be less than $25,000. So just keep keep that abreast. Whether they have the funeral bill or whether they have the original will and the death certificate. So this information, the VLP will try to get this information, and when you get the client, this document will be populated.
Yeah, we will be screening for the amount of assets that they have in their estate, but it's important to know that sometimes clients aren't forthcoming, or they may not know what the estate consists of. So bear in mind that we may speak to them and they say there is no estate, but during the course of this, you may discover that there is more to an estate and they might not be eligible for this program, at which point we would then either refer them out to the lawyer referral service for further assistance. But our goal is to make sure that the cases that we're sending you out have been properly screened and that these are people who fit the criteria for this program.
And then before we get to the scope of the representation, I just want to note, I'm going to share my screen again, what we're looking at here. So this is the combined course materials. It's actually called the full course materials. And we've provided an agenda here that we're operating off of this. So right now we're about to hit scope of representation, and the page numbers are referenced to try to make it as easy as possible on you. So that document that we were just looking at is the VLP intake checklist. So going back to the scope of representation, we have two programs, basically. They're applications for voluntary administration under SCPA 1304, and then collection of assets without administration under 1310. I'm going to speak on the voluntary administration, and Kerry is going to speak on the collection of assets without administration on that affidavit. Your representation is going to go from the point of being retained up until a fairly early stopping point. With voluntary administration, your representation is going to end upon appointment. And at that point, we'll get to this a little bit later, but we're going to have you send a letter of disengagement once you've gotten the client appointed as voluntary administrator. And then if you would like to continue to represent the client privately, that's fine. But to be clear, we need this letter that will show you a template, or another letter going to the client explaining that the VLP representation has ended. And now if you're continuing to represent the client, that's going to be done privately. As to the collection of assets without administration, you're going to represent the client from the point of retention through the execution of the affidavit. You provide them with the fully executed affidavit, and then they can go on their own to the institutions to collect the assets. They can, of course, come back to you to ask questions, but it's important that you let them know that the representation has ended at that point. So I just want to bring up the retainer agreement quickly. It's a pretty straightforward agreement. The point I want to highlight is this section here. To the panelists, can you see what I've highlighted?
Yes.
Okay, great. So if you're doing voluntary administration, you're going to check this box here, and you're going to fill in the name of the estate. If you have a client who just needs an affidavit in order to collect a limited amount of assets, you're going to check this second box and fill in the name of the estate. And of course, you're going to enter the information up top, and the rest is pretty much boilerplate, except for the bottom, and where everybody signs and dates, and then the client's rights and responsibilities are also to be provided, signed by the attorney and signed by the client. So the next topic is the attorney's intake. So at this point, the VLP has done their intake. They provided that intake sheet to you. Now you're the assigned attorney. So what do you do at that point? How do you begin? So Pam, I'm going to turn to you for that.
Okay.
And let me know, would you like to share your own screen, or if you want, just let me know what to share?
Just show your screen for the intake document.
Okay, so this is page 5 of the full course materials.
Okay, I'm just getting to my page 5. Okay, so in terms of the intake instructions for attorneys, we kind of got together and we put this document together so that this is your guidelines going forward. So the first thing is that you're going to get the intake form that Sydney's office will generate. So review and confirm the details on the VLP intake checklist. If the decedent died with assets greater than $50,000, then we're referring that client to the Brooklyn Bar Association. So again, just don't rely on the VLP intake sheet. Review it. It's going to be populated, but do review it with the prospective client so that you really understand what their assets are. If the decedent owned real property or co-op, then refer to the Brooklyn Bar Association because they probably have too much assets and it's going to be over the $50,000. I typically ask for identification from the client, and that is usually a state-issued ID, driver's license, passport. Please check the expiration date. This is part of the file that you want to maintain for the client, particularly if you're going to be seeing the client on Zoom. They can send you a copy of their photo ID. The funeral bill, marked paid. You will need that as well. Original death certificate. Sydney has a direct link to New York City Department of Vital Statistics. So any questions or issues there, you can shoot an email to Sydney if they do not have the death certificate, if they do not know how to get the death certificate. Sydney has, as I said, has a direct contact. And I believe there's going to be a specific day and time that our clients can actually go to the Department of Health and get the original death certificate if they do not have it. Usually they will get it from the funeral home, but if they do not have it, we have directions for you, and we'll be able to assist the client in getting that. They must have the original will. If they don't have the original will, it gets a little bit more complicated, but they need to have the original will. We talked about the VLP retainer agreement. Return a copy to Sydney so that he has that as part of his file, and that Sydney has that as part of his statistics that he has to keep for the VLP. Just as another form of information, do ask the client whether the death was a result of COVID-related conditions, so that we can keep that's part of our mission. We want to help New Yorkers impacted as a result of the COVID pandemic. Also, there's a couple of websites. We added this here earlier on when we're putting this together, but Daniel also added a more extensive list at the end of the materials to find unclaimed funds. I typically find a lot of funds for clients on this website. So you want to click on the website, put in the person's name and the city, the borough that they're from. Ask the clients whether they had a life insurance policy. Daniel now has on the screen the additional resources. We found this resource that you can, on the Department of State website, you can fill out a form and find out if they have a policy in New York State. We also have the link nationwide. If the decedent was originally from North Carolina, you can click on and by state and do a search to find out if they have assets in other states. Of course, that's not part of this, but it's good to find that they have assets in other states, and you can advise them that they do have assets, and then they can figure out how to get those assets from the other states. Okay. That's pretty much for the intake. The other information is pretty self-explanatory. And Daniel has set up a Slack database, which he's going to go over later. So we have a didactic process where if questions arise that for whatever reason is not clear in the materials, or a new issue comes up, that collectively as a group, all the volunteers will be able to send in questions and answers. So I'm going to let Daniel talk to us a little bit about that.
Yeah, so I'm really excited about this because I was trying to find a way to set up something like a listserv, like the State Bar has, where anybody who's a member could go on there, post a question or an issue, and anybody in the community could then comment on it. I went through a few different pieces of software, and I wound up just coming back to a piece of software that we already use in our office. It's called Slack. It's very easy to sign up. You don't need, it's not like Google Groups where you need to create a new Gmail account. You can just sign up with this with your email. It looks like this. This is the, I'll try to make it a little bit bigger. And what basically happens is you have channels on one side. So I've created a channel for instance, SCPA 1310 affidavit. And anybody who has a question can post it here. And then if you respond to that question, you can create a thread so that every response to that particular question winds up in a single thread. So it's nice and organized. I'm not going to get into this too much right now, but I am providing the instructions, the description. This is page 7 of the course materials. If you're not familiar with this, I created this. It's a pretty thorough background. It talks about workspaces and threads. And then I have some screenshots. And we're going to email everybody invites to join this. And hopefully we get everybody on there so that you're not just limited, if you have questions, to 2 or 3 people answering them, but anybody in the community will be able to answer the questions or provide insight. So Pam mentioned death certificates. Sydney, would you comment quickly on the death certificate application procedure, which I could direct you to the page. I don't have a page. I'll bring it up. You get started. I'll bring it up.
Start talking. So as Pam said, I'm probably one of the most powerful men in New York City right now with a direct link to the New York City Department of Health. It's not that serious. But there is a manner by which we can get death certificates for clients that we are assisting. And at the VLP, we will direct people to try to obtain their the death certificates prior to assigning them. But on Tuesdays and Wednesdays between 9 and 3:30, anyone that we're assisting can go down to Worth Street and pick up a death certificate. Only certain people are eligible to get a death certificate and cause of death. That would be your spouse, domestic partner, parent, child, sibling, or grandparent. And then other people such as nieces, nephews, aunts, uncles, great-grandchildren, great-great-grandchildren, grandniece, grandnephews can only get the death certificate. So if you're not, so we've had this issue come up already with Article 81 guardians, court-appointed guardians who are trying to establish a right to get a death certificate. And so if you're not related to the decedent, you are able to get a copy of the death certificate. You just need to establish your right to obtain the death certificate. And so as a legal representative of an estate or a party with a property right, or some sort of judicial officer, you can get the death certificates by showing an insurance policy that names you as a beneficiary or a bank account that does that. If you get a copy of the property deed, if you're a court-appointed guardian under Article 81, getting a copy of the court order appointing you. And so, so if you're not related, there are ways for you to obtain the death certificate. They are asking that prior to coming down to Worth Street, that you download the application and complete the application. You can also email them and they will send you the application. And once your submission is reviewed and approved, they will give you the application or they will give you the death certificate at 125 Worth Street. So if you're having any difficulties, again, the email address is on there for you to contact the Department of Health. So in terms of valid ID, they're looking for, it has to have your photo, your signature, and it has to be unexpired. So a driver's license or non-driver's ID, the New York State's benefit card that has a photo on it, a passport, a permanent resident card, college ID with your transcripts, an inmate ID with current release papers, any sort of job ID along with a pay stub, accessoride card, the New York City IDs work, and a MTA reduced fare card. So if you don't have any of the above, two different documents from below that show your name and address that are dated within the last 60 days, they will then mail the certificate. So a phone bill, any type of government mail that you received in the last 90 days. And so in terms of being able to search for a death certificate, it's important to know the decedent's name, the date of death, or a 3-year range. I think since we're going to be dealing with people who have recently passed away, it should be a little bit easier, but this is other information that would help facilitate to get access to the death certificate. Another way to get them is also sometimes the funeral home will have access to them. And so I know that you can request them from the funeral home and they can provide them to you. And I know that some people have had issues with getting the death certificate from the funeral home where they've actually paid for it and requested it several times and they haven't gotten it. And so it's $17.75 for the death certificate. They're looking for credit card payments or money order. And when they're going down there, your social distancing, they're asking you, you won't be let into the building if you're not wearing a mask. So if anything comes up, I have them on speed dial. I can reach out to them. Just send me your question and then I will follow up. They've been very helpful with other questions I've had so far. So if anyone has access or trouble accessing death certificates, just let me know what the issue is and I can follow up with them.
Thanks, Sydney. So our next two segments are on voluntary administration, the substance of it, which I'm covering, and then on the 1310 affidavit, collection without administration, which Carrie Archer is going to cover. And then we're going to close out with Pam talking about remote notarization, which very well may be needed for these clients.
Can I, and Danny, can I ask, there was a question about will the VLP be screening for COVID related? We will do that. So we will ask that question when we're completing the intake. And so we're also going to try to assist people where it might not be COVID related, but I think the majority of the people who have contacted us already are COVID related. I think there's a need and we're going to try to help people in Brooklyn with that need. And so we will be screening for COVID related connection.
And by the way, COVID related deaths, or rather matters concerning COVID related deaths that are uncontested are considered essential throughout the state. Okay, so my portion of the program is focused on voluntary administration. The document that you see on your screen is the outline that I was referencing before. So even if you're not able to access it now, you can see it on your screen, and it will be provided later if you're unable to get there. So we're going to cover some resources. We're going to get into the background of voluntary administration, which is the foundation. Then we'll get into the procedure, and then we're going to finish it up with some post-appointment issues and winding up representation. So quickly, the resources here, we made it a little confusing for you because we have multiple checklists in the materials. But the checklist that I'm going to refer to is right here, Voluntary Administration Checklist on page 23. And this is such a critical checklist that I'm going to bring it up here. This is from the Unified Court System, and it's a statewide form, so you have to remember that the local rules can always be a little bit different. And luckily we have Lisa Mathis here, who is the head of the administration department in Kings County. She's going to help me with my presentation on the issues that I'm not completely sure about. So Lisa, you better unmute now and get ready. But this checklist is great because it corresponds exactly with the voluntary administration affidavit. Paragraph 1 here corresponds to paragraph 1 of the affidavit, 2 to 2, and so on. So this is critical. There's also the checklist that we went over. There's the checklist that is going to be filled out by the VLP staff and sent to you. And then of course there's the intake instructions that you're going to use. And then I think one of the best resources here is going to be Slack. I'm really hopeful that that's going to provide a good forum for community support. And then finally, there's the DIY website, do it yourself. The website link is there. And I'm not sure how useful this is going to be. If you've done this type of work before, if you've done these proceedings before, it might not be that useful. But on the other hand, if you haven't, it might be helpful to get you moving. I haven't personally used it before, so it's hard for me to comment, but it's there for you to check out. So going to the background, voluntary administration, the governing statute is SCPA Article 13. Specifically, the summary procedure is under 1304. So the basics, when is voluntary administration available? Well, basically there's two elements. You have to have a decedent who died leaving personal property in New York. And then on the other hand, you have to have a qualified person who can act as voluntary administrator. And we're going to hit each of these elements. Unlike other proceedings, like full administration, the decedent does not have to be a domiciliary of New York. If you have a non-domiciliary, you can potentially probate or administer a foreign estate, but there are certain criteria for that. Article 13, there's no requirement that the decedent is a New York domiciliary. So let's talk about kinds of property first. We talked about a decedent has to die leaving personal property in New York having a gross value of $50,000 or less. But how do you calculate the $50,000? It turns out that the estate could actually be worth a lot more than $50,000 and still qualify for the Article 13 small estate proceeding. And you know, Sydney, I think we're going to have to make a small change with the intake so that clients don't get ruled out too quickly. And I'm going to go through the parts that are excluded, and then maybe we could educate the staff so they know what to look for. One of the biggest things that is excluded is exempt property. And a lot of us, even as T&E practitioners, we don't pay a lot of attention to this because we're not often dealing with very, very small estates. But under EPTL 5-3.1, certain property passes directly to the surviving spouse or children under the age of 21. So what does that mean? It goes directly to the spouse or children. It doesn't go through administration. It goes outside distribution, and it's not subject to creditors. And also, it's not counted as part of the $50,000. So what is exempt property? I encourage you to check out the statute because it'll go through it in detail. I'm just going to hit a couple of categories. I'm going to start with my favorite category of exempt property, pets and farm animals, along with 60 days of food, up to a value of $20,000 is not counted when calculating the $50,000. Then separately, one motor vehicle up to a value of $20,000 is also not included in the calculation. But I think that maybe the most important and definitely the most common is going to be cash or personal property up to a value of $25,000. I think the total amount of exempt property totals about $92,000, but for the most part, we're probably going to be looking at motor vehicles and cash. So take a look at 5-3.1 so that you know, for example, if you have an estate that consists of all cash, is valued at $75,000, that still qualifies, or it could still qualify as a small estate, because if the decedent were survived by a spouse or children under the age of 21, by the way, it's not minor children, I might have said, it's children under 21, then the first 25,000 is not counted towards the 50. What else is excluded from the $50,000 calculation? Real property. You could have a piece of property worth 500,000 and 25,000 in cash. You could still get voluntary administration. And by the way, you cannot use voluntary letters. You cannot use Article 13 to dispose of real property. Also excluded is any property passing by operation of law. So think about your joint bank accounts, trust accounts, life insurance with a beneficiary, where the beneficiary is someone other than the estate. That's not counted towards the 50,000. And finally, actions for wrongful death or personal injury are not counted. You also can't use Article 13 to prosecute an action for wrongful death or personal injury. And Lisa, I want to turn to you for this. My understanding, you brought this up in a conversation the other day. My understanding is that generally you cannot use Article 13 to commence a cause of action, but I think you mentioned an exception. Was it housing court?
Right. So you can file proceeding. There's certain, like in housing court, succession rights, and family court to go after child support. Those things you can still use the small estate to access those type of things. So and as well as insurance policies where the decedent isn't the insured but the owner of the policy, you can transfer ownership with the small estate.
And I believe that you can also, sorry, go ahead.
Let me just interrupt for a second just to give the first code for today's CLE. So the first code for today's CLE is PRB 604. I repeat, the code for today's CLE is, the first code is PRB 604. I will put it in the chat.
And I believe that voluntary administration can also be used to deal with mortgages. In other words, a lender might not speak to you if you're not one of the borrowers. But if you get voluntary letters or voluntary administration, the bank will typically speak with you. And you can often get a certificate that is for information only. So you don't know about any assets, but you need to find out certain information that might lead to assets. You can get a certificate that just says this person is entitled to get information about this decedent's estate. So the next big question is, who can serve as a voluntary administrator? This is governed by SCPA 1303, and it breaks down into two categories. You have intestate estates on one side, and then you have testate estates where there is a will on the other side. We'll start with intestate estates. Here, a voluntary administrator must normally be a distributee. There are three exceptions though. Guardians of the property of a minor distributee does qualify to serve as voluntary administrator, as does an Article 81 guardian, as does the public administrator. And I did see Charles Fiore on the call, so I appreciate you in attendance, Charles. Those are the three exceptions. Otherwise, if you're not a distributee, you're out. You can't do Article 13. So this means no designees, like in Article 10, full administration, the distributees can get together and designate another party. You can't do that here. No fiduciaries of post-deceased distributees. And no grandparents, no aunts or uncle, no grandparents, no grand aunts or uncles, and no grand nieces or nephews. And never, ever cousins. Lisa, I want to turn to you for non-marital children again, because you brought up something interesting. So according to the Unified Court System, a non-marital child of a male decedent may be required to establish paternity. But am I right that in Kings, it's generally you always have to establish?
Right, we always require it because in the small estate, the judge is not reviewing it. It's straight from the statute. So we don't have the ability to make a determination. So they have to meet the statutory requirement in the forms that they present.
And if you want to know how to establish paternity, you should go to EPTL 4-1.2. And I think also, Lisa, you mentioned that I think the DIY site, it didn't do the best job of dealing with non-marital children. Is that right?
Right. The DIY site is a good site, but it doesn't deal with non-maritals. It's not going to vet for that. And the other thing that it will do, it'll flag if you're not a distributee, but it'll still let you print out the forms and it'll say other. So it drops the ball in those two places.
Okay.
Lisa, this is Pam Walker. Can you give us an idea of what documentation a non-marital child of a male decedent would be acceptable? For example, in my experience, a birth certificate alone would not be acceptable. A custody agreement may be acceptable. If they got child support through the court, that may be acceptable.
Right. So if they have anything to show some type of order affiliation that was done through family court, so the custody determination of child support, will accept that. Acknowledgement of paternity from the Department of Health. So if the child was born after 96 and the dad's name is on the birth certificate, the dad would have had to have signed something. So we'll accept that. And then the third thing that we'll accept is if the next class of distributees after those non-marital children gives us an affidavit with that language of openly and notoriously acknowledged the decedent as their dad, that they're the children. We'll accept that as well.
Thank you, Lisa.
And next up is order of priority. So if there are multiple distributees, who's entitled to, who has priority to serve. So you see the list there: adult spouse, child, parent, siblings, and so on, ending with the public administrator. The tricky part here is that you have to remember that the voluntary administrator has to be a distributee. So this gets a little tricky in the example I have below, where a decedent is survived by no spouse and an infant child, a minor child. And I got tricked up by this a few years ago, where I thought that, well, the next person in line, you know, there was no parent, no surviving parent. The next person in line was a surviving sibling. So since there's no spouse surviving, no parent surviving, but there is this child, but the child's an infant and doesn't qualify, then let's go to the next person on the list, the sibling. But no, you can't do that because the sibling is not a distributee. You have to be a distributee in order to serve. But here, fortunately, in this scenario, there's a good solution. The sibling could go and get appointed as the guardian of the property of the minor or infant child. And through that path, then the sibling would be able to serve. But otherwise, the sibling would not be able to serve in this situation. So now we're going to turn to...
Okay, Daniel, can we
sorry,
just go back to that?
Absolutely.
I just wanted to, are you going to talk about renunciations in the small estate?
Yes.
Okay, that's all right, I'll wait.
Yeah, and that's another tricky one, so, okay. So testate estates, where there is a will. So this is very similar to probate, right? Because you're dealing with a will. Obviously, the first person in line is the nominated executor in the will, and then the alternates. Now, if none of them are able or willing to serve, then you turn to SCPA 1418, which is Letters of Administration CTA, or with the will annexed. And what that does is it provides alternatives to the nominated executors in the will. I'm not going to go through it in great detail because of time limitations, but quickly, it's right here on this outline. If none of the nominated executors are able to serve, it goes to the sole beneficiary, if any. Then one or more residuary beneficiaries, if any. And then a very broad category, one or more persons interested in the estate. And then it goes to the public administrator. And if the public administrator is not willing to take the case, you know it's a really bad case. But seriously, after the public administrator, there are additional categories of people who can serve, but we're going to skip over that here. If you want to see what those categories are, go to 1418. They rarely come up, but they are there for you. So that's the foundation of these Article 13 proceedings. So now we're going to get more into the heart of it, the procedure. So a couple of general notes. There's no waiting period like in other states where you have to wait 3 or 6 months before you can become appointed. And also certificates are normally issued the same day as you file the document. These days with the COVID environment, you can't go to the court, so it's not going to happen the same day, but there is still a very fast turnaround time. My office filed one of these recently, and I don't remember the exact length of time, but it was less than a week. I think it was just a matter of days before we had certificates. Also, there's no bond required for Article 13, and there's a $1 filing fee. So getting more into the meat of this, what documents do you have to file? Well, you have to file the official form affidavit, which I'm going to show you quickly on page 20 of the materials. This is the form affidavit. It's very straightforward. We're going to get to it in a little bit more detail and show how it works with the checklist, but it's a 3-pager, and this is the main document that you're going to be dealing with in doing these Article 13 proceedings. Then, Lisa, I'm going to turn to you again. As far as the unified court system is concerned, on the checklist, it requires a copy of the affidavit. But I don't know if we file copies of the affidavit in Kings. Does Kings require it?
A copy of, I'm not sure which affidavit you're referring to.
So that's the affidavit in relation to settlement of the state under Article 13.
Right, that's the 3-page affidavit.
Right, so does Kings require an extra copy?
An extra copy? No, absolutely not.
Okay, so there you go. In Kings, you don't need the copy. You also always have to file a certified copy of the decedent's death certificate. Sometimes clients get a little confused because this statement is a little bit redundant. It's an original death certificate. There can be more than one original, but the important thing is that there's a raised seal on the death certificate. You also always need a 207.4 certification. This is on page 60. I'll turn to that quickly. This is a document that the attorney fills out. And it just says that the forms that you're submitting, if they're computer generated, they comply with the official forms. An important thing, if you're new to this area of work or you haven't done this before, this is not a complete document. Make sure you don't submit it like this. You put this underneath the caption and then add the date and add your signature. The next document is the Part 130 certification. This is a very basic document. This also needs to go under a caption. And this simply says, this is not a frivolous application. So those are the documents that are always required. Then there are documents that are sometimes required. The first one that's sometimes required is the will, if there is one. As a note, there's no lost will proceedings under Article 13. So Lisa, am I right? If you have a copy that you want to probate as a lost will, you have to go Article 14, full probate?
You have to do a full probate. That's correct.
Okay. And then here's the renunciations that you brought up earlier. So you're going to need a renunciation from anyone with a prior interest to serve as voluntary administrator. So an example, let's say the decedent was survived by a spouse and an adult child. And the adult child comes to you and says, I want to serve as the voluntary administrator. Mom, the surviving spouse, is okay with me serving. And mom needs to sign a renunciation that indicates that she's okay with Sonny serving. She knows that she's entitled to serve, but she's not going to, she's going to renounce her right to serve. And I'm just going to bring that up quickly. And Lisa, if you want to comment on that at all.
So the renunciation is not like, the renunciation is only renouncing their right to be the voluntary administrator. That spouse would still inherit whatever assets are left after debts paid. And also the renunciations come up in the situation where you have sibling and nieces and nephews as distributees. You'll need a renunciation from the siblings if a niece or nephew is filing. And if it's a testate proceeding, you need, and say there's co-executors named in the will and only one is filing, I need a renunciation from that other nominated executor.
And then what if you don't get what if you can't get a renunciation? What if mom really wants to serve, but Sonny wants her to renounce? Are you just out of luck?
Then they can't file.
For Article 13, so then you're going to have to either go full administration or full probate?
Correct.
Okay. Okay, and then lastly, a copy of the funeral bill. And Lisa, since bonds are not required under Article 13, does it matter if the funeral bill has been paid and is marked paid?
No, in Kings, we don't require that the bill is marked paid in full, because sometimes the reason why they're filing it is to obtain the assets to pay for the funeral.
Okay. So now we're going to get even more into the heart of this, the main document here, the affidavit in relation to settlement. This is on page 20 of your materials. As I said, it's a straightforward document. It's 3 pages. You can also go, I'm going to show you in the agenda where you can find this. So voluntary administration affidavit, page 20. What we've included in the materials is a PDF. To make it as easy as possible on you, we've also provided the hyperlink here, which takes you to the court's website. And you can download the same affidavit in any format you want. Now, PDF is fine, but sometimes it just doesn't work out in the way you need it to. So you can download a Word document version, and I find it easier to work with. So this is the same exact affidavit, but in Word. Now, we're not going to go through the affidavit step by step, because as I said, it is very straightforward. And if you use the checklist on page 20, it just spoon feeds it to you. So what I want to do is just focus on a few of the highlights, a few of the areas where there's something of a wrinkle or it might be a little bit confusing. So the first one I want to identify is paragraph 5. In the instructions or the checklist, it says that you should go and search the court records for any previous applications. And then on the actual affidavit, there's a statement that says, I went and searched the court records. But as we know, you can't search the court records these days. So Lisa, is there any word that's come down within the court system as to how this statement should maybe be reflected or revised?
No, they haven't addressed it, but the clerk will check to make sure there hasn't been something filed before it gets to check. The clerk will check and the cashier will check to make sure there's nothing already on file.
Okay, perfect. So the next wrinkle is in paragraph 6, where the instructions, they indicate that a family tree, not an affidavit, but a family tree should be submitted if required. So Lisa, in what circumstances does the court want to see a family tree?
Okay, so I rarely ask for a family tree, but if you're down where you have a lot of children, an issue of predeceased, or a lot of siblings, an issue of predeceased siblings, then I'll ask for it. But most of the time, the family tree affidavit is sufficient.
Okay, and that's what we're going to get to next. Now, I want to get your input again, because under UCS, under the instructions, it refers to this affidavit under Uniform Rule 207.16c. It refers to it as an affidavit of heirship. But in Kings, it's referred to as the family tree affidavit, right?
Right.
Okay, and I'm going to pull that up because this is an important document that is often required. It's on page 61 of your materials, and this is a local form. This is provided by the Kings County Administration Department. And it's a very straightforward document again. The affiant indicates their relationship to the decedent, and then they answer a bunch of questions. Mostly yes or no. Sometimes you have to add a little bit of information. So I'm not going to spend a lot of time going through this, but it is here on page 61 of your materials. So one question that comes up often is, who can attest to the family tree. So this is another wrinkle, Lisa. My understanding is that it must be a disinterested party in all cases, and it cannot be the spouse or child of the distributee. But I think in King's, you only require it for one of these scenarios, right?
What happens is we comply with, for the small estate, we comply with 207-16C. So if it's a sole distributee, I need it from a disinterested. But if there are multiple distributees, because we're going to send them notices, the affiant who's filing it can fill out that family tree affidavit.
So if there's multiple distributees, then the affiant, an interested party, can fill it out in that circumstance?
Correct.
Okay. Now, one thing that I'm not familiar with, in the instructions, it refers to providing police vouchers. Can you explain when police vouchers or I believe property clerk vouchers are required?
Sure. If the person lived alone and passed away in the home and the police go in, they'll take the keys and anything that's around that they see as valuable, and they'll voucher it, what they call a police voucher. They have their information and they list whatever it is that they're holding. So most times, in order, we can give them the voluntary administrator a certificate to have the seal removed from the apartment, but they don't have access to the keys. So we have to give them a separate certificate for the vouchered items to be released. So we want to see a copy of those vouchers in order to give them that certificate. So we get it in instances where, like, there was a crime and the person passed away, and the police vouchered stuff that were on their person and their vehicle. When apartments are sealed, sometimes we get them if people passed away in a hospital and they vouchered expensive things. So.
Okay, great. That's something that's never come up for me before in this circumstance. So when you've got this together, you've got your affidavit, you've got your supporting documents, whichever documents are necessary. We're then encouraging you to use the cover sheet that we're providing for you. It's on page 27 of your materials. And what this does is it really makes it easier for you and for the clerks to review. Page 27, you're always going to have the affidavit in relation to the estate, the family tree affidavit, and most of these other documents, but you don't necessarily need every document here. For example, if there's no will, you're not going to be including the will. You're only going to be including police vouchers if there's a need for it. Same thing with establishing kinship. So what you should do is put your package together, check off the documents that you are submitting. You're going to indicate your name at the bottom and the date, and then you're going to submit this right on top of your application to the administration department. And this will also be a signal that this is a case and an attorney who is pro bono through this project, and it'll highlight that these applications need this attention because these are really essential applications. Everybody that's in this situation, I shouldn't say everyone, but most people really view this as an essential application.
Daniel, this is Pam Walker, and including that form on the package is really important for our data collection, because Lisa will see the form, she will get the form, she'll indicate on the bottom whether a certificate was issued or not, and this form will now be sent over to us, and we'll get it to Sydney so that Sydney knows that the loop has been closed. So he's involved with the initial intake, but now we know that the certificate has been issued. So this is really important for Sydney's data collection, for our data collection, and it's the indication of the completion of the file. So please do remember to include that. Thank you.
Yeah, you will also, Anna Grady, who's our pro bono director, will also reach out to just check in, and we have a case closure form as well that will send so that we can track, and then we will follow up. We follow up on a regular basis to make sure.
Right.
Okay.
Okay. And then closing out that application process, once you do submit it and hopefully it does get approved, you're going to get one certificate for each asset listed in the affidavit, as Lisa alluded to. So if you have some property on deposit with the police and you have 10,000 in Chase bank account, and you have XYZ, you're going to get three certificates, one for the vouchers, one for Chase bank account, and one for some personal property. And as I mentioned before, you could also get a certificate that indicates for information only, if that's what you're looking for. So now you've gotten your client appointed.
Can I just
sorry.
add one thing?
Absolutely.
Okay, so you'll also get a certificate to open the estate account, because those funds have to go from the decedent's account into the estate account.
And that's a piece of information that you're going to want to provide to your clients once you get them appointed. And we've provided a sample final letter for you to give your clients, and it's in there along with a bunch of other instructions. So once you've gotten the certificates, then if you want to go back, and let's say you get a certificate for information only, and then you find a couple of assets, or you get certificates to recover assets, and then you find more assets on top of those, and you need more certificates, you would then use the amended affidavit form, which is on page 32. We'll flip to that quickly. This is very similar to the initial affidavit. It's another form that can be found through the same link on the website. So here we have you can use the same link right here for voluntary administration affidavit, as well as the amended affidavit that's on page 32. Now, as I'm going to tell you in a minute, this is going to fall slightly outside the scope of your representation, and we can get to that now. So this is the last segment, post-appointment. You've gotten the certificates, and you need to let the client know you've been appointed, here are your certificates, and this concludes representation. As I mentioned before, if you want to continue to represent the client, as we often do after appointment, you can do that on your own and privately. It just needs to be made clear to the client that the VLP representation has ended, and now if you are going to continue representing them, it's going to be on a private basis. So I'm going to jump over to page 28 to give you, let you see the sample letter that we put together. You can, of course, change this as you see fit, but the general idea is that you're indicating that the court appointed you to act as voluntary administrator. Your certificate or certificates plural is enclosed, and this brings legal representation to an end. Lastly, here is some more information that is very important for you to know. And we have a number of issues here that we comment on to give to the client about fiduciary duty, about the responsibility to segregate funds, keep records, all sorts of minutia. And then just note that this needs to be tailored to your case. Everything in italics needs to be touched upon, but you should be looking at this whole thing to make sure that it all appropriately applies to your case. We recommend that you provide this letter along with the certificate of appointment, and also you provide a report and account, which is required. The administrator is required to file a report and account. It's like a mini accounting. It's not a full judicial accounting or anything like that. The statute 1307 indicates that they must account for all personal property of the decedent received and dispersed, et cetera, by filing this report and account with the clerk. Now that report and account falls outside the scope of your VLP representation, so we're recommending you just provide them with the document, and then they can go and fulfill their obligation. If you choose to continue representing them, then you can help them with that. So that concludes my portion of the presentation. Sydney, looking at the time, do you want to take questions now?
I
Or
was
do you
just
want
going
to
to ask
wait,
you,
wanna
I
wait
think
till the end? I'm happy to stay late.
the last part was, I think there was a question about obtaining a tax ID number. Is that part of the representation? And I think you just answered that, right?
Yeah, really, once you get the certificates, you're just giving the certificates to the client, and then that's it.
Okay.
It's their responsibility to get the tax ID, and I believe we have that in there. I hope we have that in there. But if you feel like you want to add any additional advice, you're entitled to do that.
Okay. The other, there are only a few questions. Currently, we're filing these petitions by mail or in person. I think the courts are still closed. So Lisa, are they only being accepted by mail at this point?
We have a drop-off bin at the county clerk entrance for emergency applications. I don't know what's going to happen after next week, but in prior weeks, I've been in and a cashier has been in on Wednesday. So people have actually been able to walk out with their certificates the same day. But as I said, those are really for emergency. Otherwise, you should be mailing it in.
Okay.
Yeah, and I just want to mention, I went through one of these recently, and mailing it in, and it all worked out fine and quickly.
Okay. The other question was, what if there is no funeral because the body was donated?
We'll see that on the death certificate, and if we miss it, just flag it, and we won't ask for it.
Okay. And then the last question was, if their person has property outside of New York, does that mean we can't help? That's something that we will try to screen for when we're doing the intake at the VLP. So we will probably screen that out before it even gets to the point where it's referred out to you,
Yeah,
to the volunteers. And if you determine during the representation, then we'd have to address that issue.
and I'm speculating a bit, but I believe that the Article 13 administration does allow you to collect personal property outside the estate. Sorry, outside the state. I'm not 100% on that, but I suppose it would. No, that's never come up before for me, but it was something that would have to be looked into.
So I could just piggyback on that. So to have standing to file it in my court, either the money has to be in Brooklyn or the decedent has to live in Brooklyn. But if they have standing that way and they have also personal assets in another state, if they'll honor those certificates, if there's reciprocity, then they can include it as assets to be collected.
Any other questions, Sydney?
There is one, wouldn't that be a matter of law of the state where the other personal property is located?
It would be, but there's the issue of comity. So New Jersey respecting New York's laws. And I don't know the ultimate answer to it, but my feeling is that there would be, it would be honored.
Right. We usually advise them to check with the jurisdiction, the parties in that county, because sometimes they will honor the certificates from New York.
And I think that situation would come up where you have, let's say, a hyper-local bank in Florida, where they have no branches, no affiliation with New York. But otherwise, most banks, they have offices in New York, and it's not going to be a problem. It could come up. I mean, there are a variety of circumstances where it could come up. They just tend to be rare.
And the other jurisdiction may require an exemplified copy of what has been filed in New York.
Yeah, if you're going through a court proceeding there, yeah, it's possible.
Okay. So do we want to go on to the next?
Yeah.
Okay, so next up we have Carrie Archer on SCPA Article 1310.
Yes, so SCALPA 1310 is the collection of assets without an administration proceeding. And under the statute, the law allows certain relatives of the decedent to collect money without filing any papers in court. The law also allows anyone that paid for the decedent's funeral to get repaid from the decedent's funds, again, without the court administration. This is done through the use of an affidavit. We call it the 1310 affidavit. what would you need is you need the affidavit along with a copy of the 1310 statute and the original death certificate. All these documents gets presented to the financial institution to request the release of the decedent's funds. Please note that the 1310 affidavit cannot be used if a fiduciary has previously been appointed by the court. So you can't be an administrator or executor or even have volunteer administration letters. You must do it before you apply for volunteer administration letters. For the purpose of this small estate project, we will be focusing on SCALPA 1310-2 and 1310-3. So 1310-2 deals with the surviving spouse only, and it states that upon the death of the decedent, the surviving spouse may collect up to $30,000 in assets. There is no waiting period. There is no time restriction. It's immediately upon the decedent's death. The spouse can collect the $30,000 in assets. This can be from different financial institutions, and when I say financial institutions, that can be a bank, that can be life insurance, that can be a brokerage account. It does not deal with real property. You can't use the affidavit to liquidate any real property. So if you have $15,000 at bank A and you have another $15,000 at bank B, you will use two different affidavits, and you can receive the money along with a copy of the statute and the original death certificate. It cannot exceed $30,000. So the statute, all the language that's required by the statute is actually in our sample affidavit. In the materials, you do have a sample 1310-2 affidavit, and all the language is in there. You mainly need to just fill out the spouse's name, the decedent's name, the spouse's address, as well as the date of death, what financial institution do you want to withdraw the funds from, and also the account number if you know, and then the affidavit must be notarized, signed by the client and notarized. And you would take that affidavit along with a copy of the actual statute and the original death certificate and present it to the financial institution, or you can mail it. We would recommend certified mail return receipt. And then the bank or the financial institution is supposed to honor the affidavit. The 1310 affidavit, 1310-3 affidavit mainly deals with other relatives. For this affidavit, there is a time restriction. So after 30 days have lapsed from the date of death, you may collect up to $15,000. And this can be collected by the spouse, children, parents, siblings, nieces and nephews, or a creditor who has paid the funeral expenses. The list of relatives is in priority. So you have to make sure if there's a spouse, the spouse will have to do it. I would recommend if you have a spouse for you to use the 1310-2 affidavit and only use the 1310-3 affidavit for other relatives, or if the spouse needs to pay someone who paid the funeral expenses, then that spouse will use the 1310-3 affidavit, but is limited to $15,000. So although the statute allows for payment for a funeral creditor, the creditor cannot collect the money alone. The request of the payment for the funeral expenses must be made in conjunction with either the spouse or the other relative. So it must be on the 1310-3 affidavit, which we have that in the materials as well, that the spouse or the other relative consents to the payment to the funeral creditor. Along with the 1310-3 affidavit, a statement of heirs must be filled out, or a family tree affidavit, and it must be attached along with the affidavit. We've also supplied a sample of that, and that's only for the 1310-3 affidavit. You don't need it for the 1310-2 affidavit. Our representation under the VLP is limited to filling out the form with the client, and then we have a closing letter that will give the client stating that they either should present the documents in person, or they should mail it, certified mail return receipt, and then they should follow up with the financial institution in a reasonable time frame if they haven't heard back from the financial institution or they have not received the funds. At the conclusion of that, if you want to continue on, it will be a private representation, but the VLP's representation is concluded on just filling out the affidavit. Is there any questions?
There was one question. I don't know if it was related,
No.
but
Yes, so if there's more than 30,000 assets, you should do the 1304 petition. The affidavit is limited to 30,000 for the spouse and 15,000 for other relatives. And again, the other relatives is a time restriction. It's only after 30 days have passed, but with the spouse is immediate.
okay. There was a question where the decedent has a disabled child, and then the decedent's sibling files for administration or voluntary letters. Will the case be delayed until the disabled child is appointed a guardian?
Well, it doesn't sound like that could happen. Can you give me the facts again? The decedent was survived by just a child, and the child's disabled.
Right.
And then what's the next step?
Decedent's sibling files. The person put for administration.
Okay, so, well, if we're talking about voluntary administration, then the sibling can't file until the sibling gets appointed as guardian of the property. So the answer is, yeah, it will delay. You can't do anything under Article 13. But there may be an avenue under Article 10, full administration. But in that situation, you can't do Article 13.
Okay.
So I see a question about, is the 15,000 inclusive of the funeral bill? Yes. So it's only, it cannot exceed 15,000. So that will include if the funeral bill was 10,000 and then there's a $5,000 bank account, then you will be able to use 2 different affidavits to retrieve those funds. If there's anything above that, you will need to do the 1304 petition. The affidavit is going to be limited to banks and assets in New York, so we're not going to be dealing with any out-of-state institutions unless it's like life insurance. Then you can proceed with it, and the financial institution should honor it. If there's any pushback from the institutions, you can reach back out to their attorney. But again, the financial institutions are supposed to honor these affidavits because they're only for limited funds.
And that, in my experience, it's a big supposed to, you know, they don't always do it. It all depends on who you're dealing with at the bank. You might just get somebody, a teller or a manager who has just never seen this before, and they're going to look at you like you have 2 heads. But most bankers tend to know what it is, but just so you're aware, this isn't always going to work. They're supposed to honor it, but they don't always do it.
Okay, Pam.
Okay.
Well, let's see. I think, Sydney, are there any more questions?
Nope.
Okay. All right. You're up, Pam.
Great. Hi, everyone. So if you notice, a lot of the documents will need to be notarized, and the governor has provided us with an opportunity. Prior to COVID pandemic, New York State was not one of the states that could do remote notary, but we are now. So based on the governor's executive order 202.7, 202.14 extended it, and 202.28 extended it even further. I checked last night. The last extension in 202.28 is through June 6, 2020. We have not seen an update as of last night, but we will definitely keep you posted on Slack. Once we get the extension. Everybody is expecting an extension. So based on 202.7, we can do remote audio visual notaries. I've included, Daniel has included in the material the guidance to notaries, and this we found on the Department of State website. I'm going to give you some of my experience in doing this. I've been utilizing remote notaries over the last, since mid-March, when this came out. And typically I've been doing this through my iPhone FaceTime or doing it through Zoom or Skype. So the first question that I always ask the person I'm giving the notary for is, where are they located? You must be located in the state of New York. That's the first item. The second item, you ask them what county they're located in. So most of the notaries that I've been doing has been in Kings County, but I did notarize some things in New York County. So on the document, if it's asking you the county where the person that's requesting the notary, that's their location, wherever they're located. Best practices has indicated that if we're in a different county from the person we're notarizing the document for, we should indicate that on the document. We should say that the notary is located in New York County, even though the person you're taking the notary for is in Kings County. So in the notaries that I've been doing, if we're in the same county, I have not put it on, but if we're in different counties, I will indicate it. I will also indicate on the document that this is a remote notary based on Executive Order 202.7, 202.14, and 202.28. Once we have the update, of course, we'll put the other information on. So typically when I'm doing this on iPhone or Zoom, I have the client scan me the document beforehand so I know what I'm notarizing, and then we get on Zoom. It cannot be pre-recorded. It has to be live. So the client will put their ID up to the screen. I've been taking a picture of that ID on the screen, and the person is in the background. And of course, I'm in the upper right-hand corner of the screen, so I have everybody on film now. And then I actually have the client position their phone or their iPad or their computer, so I see them notarize the document. Then I ask them to take a picture of the document with the signature, scan it over to me, email it, take a picture with your phone. I recently found out that if you have an iPhone, if you go in the notes section, there's a camera there. You can take, they can take a picture of the document and they can adjust it. There's a way of, if the picture is kind of skewed, you can kind of organize, you can frame it. Not quite sure why iPhone hid that in notes, but I found it. And then you can email that over to you. I print it out from my computer, I sign it, I notarize it, take a picture, and I send it back to the individual. Then the individual must send it to you within 30 days, the wet signature. I get that in the mail, I sign that, I put the notary stamp on it, and then I send it back. In our case, they send the wet signature to you, you sign it, put your stamp or your seal on it, put your cover letter from VLP, and then you're submitting it to the surrogate court. When the courts open up, you can send the individual to the clerk's office on the main floor, but they must have a copy of their ID. So they would go to the clerk's office on the main floor. I typically go through the entrance right by the parking lot that faces the Brooklyn Law School. I typically go into that entrance, it's not as busy. And they go to the clerk's desk. For notary, there's a big sign. They present their original ID, valid ID, folks. That's a driver's license issued by United States somewhere. Passport, please check the expiration dates on that. They take that over with a copy of their ID. They give the photocopy into the clerk at the desk, and the clerk will notarize it. When we were preparing for the presentation, Lisa mentioned that there's a USPS office, store near the court. I will find the address and I will put it on Slack, and they can have it notarized there as well. And I believe there's a nominal fee. There is no fee in the clerk's office. They've notarized a lot of my guardianship paperwork. There's no fees there, but you must have a valid state issue ID with you and a photocopy. If the client shows up with the photocopy on the other side by the windows, is the photocopy machine, and you could put in a quarter and you can get a photocopy of the ID and take it over to the clerk, and they will sign the documents. Does anybody have any question regarding remote notary? Okay, so I have a question here. Please clarify which county to use if you and the client are not in the same county. Typically, on the document, you're putting the county where the client is located, okay? But if you're in a different county from the client, right where I write remote notary, I will put that the notary is in New York County. So if the client is in Kings County and you're physically sitting in New York County, I would indicate that where you're putting remote notary under pursuant to Executive Order 202.7, 202.14, 202.28, I will put the notary is physically located in New York County, so that we're in compliance with the executive order, as well as in compliance with the best practices for remote notary.
There is a question, but let me just do the second code for today's CLE. So the second code for today's CLE is PRB 620. I repeat, PRB 620. The question was, are you going to have clients come back and execute the documents in person?
Well, a couple of things. The clients, it depends on how we're seeing clients right now. I mean, my experience right now is I'm not seeing a lot of the clients. I'm seeing them on Zoom. So we go over the documents. If you email the documents, they have the capability of downloading and emailing the documents. Then you can notarize remotely, and then they can send you the originals. Or in some cases, if they don't have the equipment, unfortunately, the public libraries are closed right now, and that's a way of going to print out documents if you help the client on Zoom or iPhone FaceTime. The clients can also access their email accounts from, I believe, Staples or FedEx. You can go in and print out the documents, and then you can notarize it by Zoom, or you can, I've also done this, send the package to the client of all the forms and documents. They now have the hard copy, and then you get on Zoom or FaceTime and you remote notarize the document. Or when the courts are open, they can go to the clerk's office and get it notarized. Or I believe UPS is doing notaries. So I will get the address of the UPS near the court. Any other questions? I think we're good.
Okay, thank you everyone for joining today. Please do the survey at the end of this training. When you exit, it'll pop up on your screen. We want the feedback. And we will be in touch soon once we have clients lined up and ready to go. And I believe we do have a couple. So you'll be hearing from the VLP very soon. Okay, thank you to all the panel.
Cindy, I just have a question for you. Well, first I wanted to note, we're going to follow up with an email to everybody. So just to make sure you have all the materials, all the information for Slack, everything that you need. And then Sydney, how are the referrals going to work exactly? Someone does the intake at the VLP, and then how mechanically is that client going to get to us?
We will contact the people that we have on our list as attendees and say we have the following cases available, and can you take it? And so the people who respond first will then be assigned those cases.
Okay, great. Thank you, everybody.
Right, and everyone, thank you so much for coming, and all the participants. Daniel, thank you so much for leading this process. Kerry, thank you for all the hard work. Lisa, thank you so much for your technical assistance. Sydney, thank you for sponsoring this and hosting us and helping us through this process. Once you set up with Slack, and I'm so amazed by Daniel Antonelli's technical skills. I want to be a little bit like him when I grow up. Once you set up the Slack, Carrie and I did it this weekend, and I think it was pretty straightforward to set up. You can even put your cute picture up like I did. Please send us questions. We're going to be on Slack. We're going to try to support you as best we can. If you have questions, the entire group can respond to the questions. If we don't have the answer, you will believe we'll be on the phone with Lisa to get the answers. And if Lisa can't help us, she will find someone else who can help us. So it's really a group effort. We so thank you for volunteering at this critical time. And we're going to be here to support you as much as we can through this process, so that this whole project is as successful as possible. Thank you.
Hear, hear.
Thank you, everyone.
Thank you.